Afternoon session 12 p.m.
The court said, "Please have the witness brought back and the jury brought in."
Jury present.
The court said, "Please be seated, and please remember that you're under oath."
The witness said, "Yes."
The court said, "You may continue the cross-examination."
Mr. Kamraju said, "Thank you, Your Honor."
By Mr. Kamraju.
Now, Ms. Schottenheimer, I think when we broke off, we were talking about the peg, right?
Yes.
By the way, do you know why it's called a peg?
So technically, the Hong Kong dollar is banded to the United States dollar. I don't know where the term.
The court said, "One moment please."
Mr. Kamraju said, "Sorry, Your Honor."
The court said, "If you would ask the question again please."
Mr. Kamraju said, "Absolutely. So I think the question you were responding to is, do you know why it's called a peg?"
My response was the Hong Kong dollar is banded to the US dollar. Which means it trades within a band, not a peg. And I don't know the origination of the term peg.
Okay. But it's commonly referred to, and you on direct were talking about it, as a peg, right? That's the phrase that we're using.
Yes.
Okay. And before we broke, we were talking about the peg potentially breaking, right?
Yes.
Now, Hayman had a view that the peg would break at some point in the future, right? Or could break at some point in the future.
Break to the weak side, yes.
Okay. But Hayman's view wasn't that that break would happen immediately, right?
The timing of the decoupling of a 40-year peg is tough.
Right. So, for example, in June 2020, the prodigious fund closed, right?
It had its first closing June of 2020.
Okay. So that was the first closing.
The first closing was June 1st.
Hayman wasn't anticipating that the peg was going to break by July 4th of 2020, right?
It's hard for me to recall that many years ago, but I do know that Tranche 1 and Tranche 2. The initial closings of June 1st and June 8th were buying options that expired at the end of 2021. So we were kind of giving ourselves roughly like a year and a half runway.
Okay. And do you mind you used a term there. Options and runway. Would you mind just explaining how those two concepts go together?
Yes. In the Prodigious series, we were purchasing options on the Hong Kong dollar outside of the band. So basically, it's a call option on the US dollar and a put option on the Hong Kong dollar. Meaning we were long the US dollar and short the Hong Kong dollar. They were struck at 7 spot, the option price was struck at $7.85. So meaning the option would be in the money, or triggered once the Hong Kong dollar traded outside of the band on the weak side. So 7 spot 86, 7 spot 87, all of a sudden, that option is in the money. And the term runway is me in my words is that we were giving ourselves 18 months, roughly, or 17 I guess, 19 months of time for this thesis to play out with the options that we were buying for tranches B1 and B2.
And in very, general terms, the thesis envisioned this being sort of a gradual process, right? How about this? Let me withdraw that question and try a different one.
Okay.
The thesis envisioned that this could be a process that would play out over some time.
I recall how the trade was set up with this 19-month duration. And I recall us wanting to get the money invested in the options in a careful and timely manner. I can't exactly recall the specific question that you're asking. We wanted to be set up and positioned sooner rather than later, so we could be fully invested to capture any potential move in the Hong Kong dollar.
Got it. All right. Let me try it a different way. Let me ask a better question. Mr. Kamraju said, "Can we bring up what I believe is in evidence GXHN 27, please? And can we just go to page 2? All right. So I believe you testified about it on direct, right?
Yes.
This is the prodigious fund deck, is that fair to say?
Yes,
All right. So and by deck, we just mean presentation, right?
this is the initial investor presentation from May of 2020, correct?
This is what would be sent out to investors to give them some sense of what the fund was about.
In May of 2020, there was iterations and updates along the way.
Sure. And just sticking to May of 2020, to this version for the moment. Mr. Kumraju said, can we go to page 35, please? All right. Do you see the second bullet there that says, targeting effective average duration of portfolio of roughly 12 to 14 months?
Yes,
What does that mean?
this is referencing the average option expiry of this initial kind of portfolio or closing. So when you're buying options at different periods of time, it wasn't that we could just overnight put all the money to work in a single option. So as you're buying options over the course of June, July, and maybe August, I think that this is kind of underpromising, in hopes that we can overdeliver an effective duration of 12 to 14 months. I'm trying to recall if we were buying all one-year options. I think that's right. Okay. If I could just
Take your time.
start over.
Take your time. Go ahead.
We were focused on buying one-year options for the share class B. And so when we purchased options in June, they would expire June of the following year. And we would purchase options in July, they would expire July the following year, and August and so on. And I think that we would hold back some of the cash in order to purchase some options in December of 2020 for the last expiration, to be December of 2021. So the goal was to put the exposure on with all of the options expiring by December of 2021. And the effective duration of the portfolio, meaning the average duration of the length of the options at any given time, would be between 12 and 14 months of coverage or exposure to the trade.
Got it. So is it fair to say then that Hayman wouldn't know if it was right about this particular tranche until December 2021?
Correct. Because with the goal of purchasing options that didn't expire through the end of December of 2021, we wouldn't have been completely wrong until we knew if all of the options expired worthless or not.
So even if you lost money during that time period, the investment thesis wouldn't have been proven wrong at that point, right?
Correct.
And I think you testified on direct that the strategy was a 12 to 24 month window or something in that range. Right?
So, yeah. It depends on the timing that we have these tranche closings, but, yes. It's between kind of historically, it's been 12 to 24 months, as the duration of these tranches.
And, in fact, the HHKOF is still in existence, right?
Both share class A and share class B still has tranches.
So Hayman is still using the same investment thesis or a similar one at least today?
Yes.
Okay. Let's flip back to page 2 of this, if you don't mind, please. All right. So who's depicted here again?
This is the leader of the Communist Party of China. His name is Xi Jinping.
Thank you. Sorry. I didn't mean to cut you off. What is he doing?
He is blowing the flowers, the petals of the flower that's on the Hong Kong flag.
Okay. And this is in the material that's being marketed to potential investors, right?
Yes.
Mr. Kumraju said, can we go to page 29, please? What's the title of this slide?
When investors last worried about Chinese law in Hong Kong.
And what does this slide depict?
This slide depicts a fairly substantial devaluation in the Hong Kong dollar primarily from 1981 to 1983.
Got it. And what is the title intended to convey?
I believe around 1983. Britain announced that they were going to Britain, had Hong Kong was a territory of Britain, for lack of a better term. And Britain was announcing that they were going to hand back Hong Kong to China. I think it was in like 19 in Britain, was no longer under UK law effective 1997. And I think there was an announcement to that effect sometime in the early 80s. That at some point it was going to go back to China. So when investors last worried about Chinese law in Hong Kong is around the time of this announcement. And that's around the time that the peg was put in place to stabilize the currency, to the best of my recollection.
Fair enough. Mr. Kumraju said, could we go to page 26, please? Can you just read the title of that slide?
Beijing Liaison Office draws line in sand in Hong Kong on the 5th of February, 20.
And then could you read that first bullet point?
Saturday. Beijing's liaison office in Hong Kong warned that the city would have no future if radical anti-government protests returned to chaos and violence at the time, requiring unity to fight the coronavirus crisis.
And what is this bullet intended to convey to investors?
Given that this presentation is 3 years old and we no longer have this in our deck, it's unclear to me.
Okay. Mr. Kumraju said, can we go to page 31, please? Do you see the title, Pegs Are Meant to Be Broken Argentina, right?
Yes.
So what's the purpose of including this slide in the deck?
I can't recall.
Okay. The purpose of the deck was to give some flavor of the investment to potential investors, right?
It was our body of work, our research in conveying our thesis to investors.
Right. And you wanted to show the investors there was some evidence for why the thesis might work, right?
Yes.
Right. You wanted to substantiate the idea in investors' minds, right?
I would describe it as we wanted to present our well-researched thesis.
Right. You wanted to make sure they understood it wasn't like a half-baked investment thesis, right?
That it was a thoughtful thesis.
And this slide depicts a time when another country's peg was broken, right?
Sitting up here today, I can't recall what Argentina is pegged to. And so it's hard for me to discuss this slide.
Mr. Kumraju said, okay. Let's go to page 34, please. So what's depicted here?
This is a dragon crunching down on Hong Kong, and an umbrella that says democracy across it. This is China clamping down on Hong Kong's system of democracy.
And is there any significance to the fact that the umbrella is yellow?
Not to me, no.
Now, in addition to this presentation, investors would also receive something called a prospectus, right?
Generally, yes. We call it a confidential, we call it a private placement agreement.
Okay. We can call it that. Like a PPM.
PPM.
PPM. Okay. We'll use that. Mr. Kumraju said, could we bring up Government Exhibit 29, please? Thank you. All right. So let's just start on page 1. And I think you testified about this on direct.
Yes.
So this is the email, you sent this email, correct?
I did.
You were sending it to potential investors, right?
That it indicated interest in the share class B closing.
And one of the documents that you sent was the PPM for the HHKOF, right?
Yes, confidential offering memorandum.
Got it. Mr. Kumraju said, can we go to page 197 of the PDF, please? All right. So this is what we're referring to as the PPM, correct?
Yes.
Or if the proper term is confidential offering, I'm happy.
Some funds call it a PPM. This one is obviously a confidential offering memorandum.
Okay. So this memorandum is intended to convey more detailed information about the potential investment to investors, right?
Yes.
So it's got a number of different sections to it, right?
It does.
And there's a lot of work that goes into putting together one of these documents, right?
Yes.
So you get Mr. Base contributes input to it, right?
This particular offering memorandum I can't say that he had input in it, no.
Okay. Let's divorce it from this particular one for a second. Just the process at Hayman.
Yep.
Can you tell me, you're putting together a new tranche? What's the process for preparing a confidential memorandum offering?
So it's at the fund level. So this was in existence prior to the prodigious series closing for the initially on June 1st. So the initial Hong Kong Opportunities Onshore Fund Confidential Memorandum was put in place January of 2017. It was amended for the kind of additional share Class B, and that's why it's from May of 2020. We had a previous fund that was a currency-specific fund that we kind of used the basis of that fund for the Hong Kong strategy. And there was a number of people that provided input and helped the lawyers pull the draft together. I can't attest to whether Kyle was involved in that process or not.
Okay. That's fair enough. There are a number of Hayman people involved.
Correct.
There were lawyers involved.
Investment professionals.
Got it. Okay. So all of them worked together to put together a confidential offering memorandum, right?
Yes.
And there's a lot of different topics covered in one of these, correct?
Yes.
Mr. Kumraju said, so, for example, can we go to page 198? So this is titled, Partnership Directory, right? What's the Partnership Directory?
I think it's naming all of the different kind of parties involved and third-party representation on behalf of the partnership.
Got it. And I think on direct you testified about having an administrator named SEI, is that right?
That's correct.
Okay. So that's the entity that's reflected here.
That's our third-party administrator reflected as the administrator.
Got it. And you see two headings down there's something called auditor.
Yes.
And there's a company listed there.
Deloitte and Touche.
Okay. What's an auditor?
An auditor is a third-party service that comes in and audits the fund on a yearly basis. They provide audited financials on behalf of the partnership to its underlying investors.
Mr. Kumraju said, could we go to page 224, please? All right. So this section is titled, Investment Program, right?
Yes.
And then there's something entitled, Investment Objective and Strategy.
Yes.
What's this section, just generally, what's this section intended to convey?
This is describing the thesis of the fund.
Okay. So the investment strategy basically?
Yes.
All right. And the purpose here is to give a more detailed explanation to the investors and what's happening, right?
As part of the offering, yes.
Mr. Kumraju said, could we go to page 235, please? And you see the title, Certain Risk Factors.
Yes.
What's this section intended to convey?
Outlining the risk factors of investing in the fund.
And the first risk factor, it looks like it says market and risk investment risks, right?
Yes.
Is that a particular type of risk? Let me withdraw and ask it this way, this is one bucket of risk that the PPM would convey.
Is outlining, yes.
And there are specific risks of investing in securities in East Asian countries outlined here, right? That's the second bolded.
Yes, that is in there.
Okay. Don't worry, I'm not going to ask you to read through the whole thing. But this is just, generally speaking, targeting risks of investing in securities in East Asia.
This is highlighting that Asia is potentially riskier than US or other developed countries.
Mr. Kumraju said, could we show just the witness, the parties, and the court GXSM 08? Ms. Schottenheimer, do you recognize that document? Mr. Kumraju said, sorry. Could we go back to the first page?
Yes.
What is it?
This is a supplement to the confidential offering memorandum specific to the prodigious series or Class B.
Okay. So it's fair to say this is an addendum to sort of the document we were looking at just before.
Yes.
Mr. Kamraju said, let me get it right this time. The defense offers Government Exhibit SM-08.
Mr. Finkel said, could I ask defense counsel a question?
The court said okay.
Counsel conferred.
Mr. Finkel said, objection.
The court said, if you'll step up, please.
Continued on next page. At sidebar.
The court said, does this addendum concern the defendant's investment?
Mr. Kamraju said, it's the same fund, Your Honor. It's just a supplement covering it. My only intention in showing it is showing that there is a supplement and it's basically the same as the one that came before it.
The court said, so what's the problem?
Mr. Finkel said, the question I asked defense counsel was, who saw it? And his answer was, I don't know. And therefore, I don't see its relevance. Because if the point of introducing this document is to show the effect on Mr. Gov't or Mr. J.E., then there is no effect if it wasn't seen by anybody. He's certainly free to ask the questions they are a supplement. That's fine. But introducing a document and evidence that may or may not have been seen by the defendant has no relevant purpose.
The court said, it was made available to them, I assume, based upon her testimony, that she hands out these documents before an investor invests.
Mr. Finkel said, that may be. But I asked counsel whether anyone of relevance had seen it. He said no. That was the reason for my objection.
Mr. Kamraju said, no, I said I don't know, because I haven't asked the witness the question. But it's just completing the record. It's a document that they make available. I'm not going to make an argument that Mr. Gov't specifically saw this document. Just completing it.
The court said, that's fine. The objection is overruled.
Mr. Kamraju said, thank you, Your Honor.
Mr. Finkel said, there's not even a understood.
The court said, are you challenging the authenticity of?
Mr. Finkel said, I'm not challenging authenticity, Your Honor. I was going to add an additional argument, my colleague said. And as I started speaking, I heard Your Honor rule, and so I'm not saying anything further. I apologize.
The court said okay.
Continued on next page. In open court.
The court said, overruled.
Government's Exhibit SM-08 received in evidence.
Mr. Kamraju said, so could we publish this for the jury, please?
By Mr. Kamraju.
So this document, you've testified about supplements before, right? Sorry, let me be more specific. Supplements to PPMs, correct?
I don't recall that. I mean, this document right here is a supplement to the PPM.
Okay. Fair enough. This one is a supplement to the Prodigious Fund PPM.
The PPM that you showed me earlier was for the whole Hong Kong fund.
Okay.
I mean for the whole Hong Kong. I believe what you showed me was an onshore confidential memorandum.
Okay.
What you're showing me right now is the supplement to the offshore Hayman Hong Kong memorandum.
Okay.
So this is not technically the supplement to what you...
No, I got that.
Okay.
I understand. Because Hayman has got two different ways in which you can invest, right?
There's an onshore feeder fund and an offshore feeder fund.
Got it. And they may have different requirements, right?
Different representations. If you're a tax-exempt US, or an offshore individual in the offshore fund.
Right. Because if you invest through the onshore, you have to pay US taxes.
Yeah, you receive a K1.
And that K1 goes not just to the investor, but also to the IRS, right?
I don't know.
Mr. Kamraju said, we can take that down. So you first met Mr. J.E. in Dallas in 2018, correct?
William J.
Yes.
I met him in Dallas in October of 2018.
Okay. And you had no further communications with him until May of 2020, right?
He came through the office and met with Kyle. I was not part of the meeting. But he was reintroduced to me on his way out.
When was that?
Sometime between October 2018 and May of 2020. I can't exactly recall.
Okay. Fair enough. Was it closer to when you initially met him or closer to May 2020?
I honestly can't recall.
Okay. You weren't part of the meeting though, right?
I wasn't part of the meeting.
So you don't know what was discussed. Other than that time that he came to the office. You didn't have any other contact with him, right?
Not to my recollection.
Okay. So during that period you didn't send him any information about the Hong Kong fund, right?
Not to my recollection.
And the first time you heard that Mr. J.E. had any interest in investing was from Mr. Bass, right?
Correct.
And that was in May 2020, right?
Yes.
Mr. Kamraju said, "Can we bring up what's in evidence as Government Exhibit HN-27, please?" All right. And you sent this email after Mr. Bass told you about his conversation with Mr. J.E., correct?
Yes.
Do you see the sent time there?
Yes.
Okay. It says it was sent at almost 1 a.m. on Saturday, right?
Yes.
Do you believe that's when it was actually sent?
It was my understanding that William was in London. So potentially it could have been 1 a.m. London time. I don't think I sent it US time 1 a.m. But potentially I work some strange hours sometimes, but I don't recall.
Well, you did testify that there was some urgency to this investment, right?
Yes, that's probably why I sent it on a Saturday.
Right. And can you explain why there was urgency?
The genesis of share Class B of the Hong Kong fund came from a reverse inquiry from an existing investor. Actually the largest investor in our flagship fund. And they wanted expedited closing of June 1st.
So fair to say that the window for the money coming in was closing pretty quickly at this point, right?
To participate in the first closing, yes. The timing had been previously set by a separate investor.
Now, Mr. Bass was pretty eager to get this investment done as well, right?
I would say that Kyle was sensitive to the timing because the current pricing in the marketplace had a good risk return to it.
The court said, "Could you explain what you mean by reverse inquiry?"
The witness said, yes. One of our current investors had asked us if they could do a capital exhaustion vehicle. So it was at a request by one of our investors to create a separate share class that was capital exhaustion or put 100% of the capital into the options-based strategy.
The court said, "Go ahead."
By Mr. Kamraju.
So there was a market reason for Mr. Bass to be eager to get this done, right?
Yes.
Okay. And then also one of the fund's large investors wanted to get this done quickly, right?
It's a separate fund, our flagship fund, but, yes, it was at their request.
Okay. And then Mr. J.E. comes along and says Soraka would like to invest $100 million, right?
I think the initial conversation was that it wasn't necessarily Soraka. But that Miles would have interest in this new structure of the Hong Kong thesis.
Okay. But the investment was really large, right?
The Soraka investment.
Yeah, the proposed investment, it was big.
$100 million investment is a large investment.
Right. Mr. Kamraju said, "Bless you."
The court said, "Thank you."
It would generate significant fees for the fund, right?
If the Hong Kong dollar had a substantial devaluation, it would create substantial fees to the firm.
Mr. Kamraju said, "Can we go to Government Exhibit HN-27, which I think is this one? Can we go to page 37, please?" All right. I think you walked through this on direct a little bit. But you see the place where it says, management fee?
Yes.
Okay. So the management fee gets paid to Hayman regardless of whether the investment thesis works out or not, right?
That is correct.
It's basically once the investment comes in, the management fee is owed, right?
Yes.
And it's the investor paying Hayman, right?
To manage the capital.
Right. And that's standard practice in the hedge fund industry, right?
Yes.
That's not unusual for Hayman or anyone else. A management fee is standard, right?
Standard hedge fund fees, yes.
And so $100 million investment at 2% would have been $2 million right up front, right?
Yes.
And then I think what you're referring to is if the bet paid off. The fund might stand to make substantially more than that, right?
Correct.
And that's the performance allocation that's referred to here, right?
Yes.
Now, at that time in 2020, I believe you testified on direct that Hayman had approximately $400 million under management, right?
Yes.
That's its AUM, right?
Correct.
And, in fact, specifically going into the closing of the prodigious fund, that April/May period. It was approximately $400 million, right?
It might have been a little less, like 300 and some.
Mr. Kumraju said, could we go to Government Exhibit HN-29, please?
The court said, "Are you speaking of total assets under management?"
The witness said, across the entire firm going into 2020 it was 400. Midway through the year, like May time frame, I believe it was 300 and change.
Mr. Kumraju said, could we go to Government Exhibit 29, please? Can we just go to first? Let's just stay here for a second.
By Mr. Kumraju.
All right. Do you see the attachments there, Ms. Schottenheimer? And I'm specifically looking at the one that's the second from the last.
Form ADV.
Yeah. Do you see that one?
Yep.
Do you know what a Form ADV is?
Yes. It's a filing required by firms that are registered with the SEC as a registered investment advisor.
Mr. Kumraju said, and could we go to page 315 of this document? All right. Is this the Form ADV brochure?
Yes, as of March 30th.
So this is the last one filed before the prodigious fund, before that June 1st prodigious fund closing. Right?
I understand this to be an annual filing.
Okay. Mr. Kumraju said, can we go to page 318, please? All right. And so at the top there you see it says Item 4, Advisory Business. Can you just read the last sentence of that paragraph, please?
As of December 31st, 2019. Hayman managed approximately $432 million in assets under management on a discretionary basis on behalf of its clients.
Okay. So by the time we get to like spring of 2020, that number has gone down a little bit, right?
To the best of my recollection, yes.
Okay. So $100 million could be anywhere, could be north of 25% of the assets that the fund had under management at that time. Right?
We had a closing on June 1st of close to $40 million. But, yes. Somewhere around 20% of assets under management.
A big chunk.
A minority.
Sure. Sure. But the next biggest investor had put in, I think, $30 or $40 million, right?
Specifically to the Hong Kong fund.
Yeah.
I think it was around 50 at the time.
Okay. So this would be almost twice that investment, right?
Yes.
And it's fair to say that when the checks got larger, Mr. Bass's involvement got more significant?
In what regard?
Well, for example, if there were particularly high net worth individuals who were planning to invest. Mr. Bass might have more face-to-face withdrawn. Mr. Bass might have more contact with them, right?
Not necessarily.
But it happened from time to time, right?
Mr. Finkel said, objection. asked and answered.
The court said, sustained.
So in this case, Mr. Bass is the one who told you about Mr. J.E., correct?
Yes,
And Mr. Bass had direct communications with Mr. J.E., to your knowledge, right?
that is my understanding.
And he spoke to him on the phone, right?
That was my understanding.
You didn't speak to Mr. J.E. on the phone, right?
I did not.
And there were times when Mr. J.E. may be slow to respond to some of your inquiries, right?
My specific inquiries.
Or the fund's inquiries. Well, let's say your inquiries. Let's stick to yours, your inquiries.
I specifically remember, after Mr. J.E. had requested the side letter, I had reached out to him a couple of times asking for the names of the entities that were investing so I could clear it for conflict with my third-party counsel. That is the only time that I recall Mr. J.E. me having to follow up multiple times to get a response.
Oh, sorry, I didn't mean to interrupt.
But it was within a matter of days.
Okay. Did Mr. Bass also try to follow up with Mr. J.E. then?
Yes. I had enlisted Kyle, the next time you talked to William. We need these names to clear them for conflict.
Because Mr. Bass had a clearer pipeline to Mr. J.E., right?
It was just whoever talked to him first was hopefully going to collect the names so we could clear them for conflict.
Now, it was Mr. Bass who originally gave you the names of the companies that were going to invest, right?
Via text.
Right. And we looked at that text on direct, right?
Yes.
Mr. Kamraju said, can we pull up Government Exhibit HN33? This is that text message, right?
Yes.
And you see at the top it says, because of the tight timing?
Yes.
What do you understand that to be a reference to?
At one point they were trying to invest as of June 1st. Along with the other reverse inquiry investor from our flagship fund.
And this text was sent on May 26th, right?
Ahead of the June 1st closing. At some point it became evident that they weren't going to make that cutoff. And so we set a date around their preferred timing.
Mr. Kamraju said, okay. And can we scroll down a little bit? So then you tell Mr. Bass that you're going to send William the AML requirements, right?
Yes.
And how does he respond?
Okay. Let's fast-track everything. Thank you. Remember, he's asleep now. He won't get back, so you won't get it back until tomorrow.
What did you understand Mr. Bass to mean when he said, let's fast-track everything?
In response to me requesting the AML requirements. That we wanted to get the AML in to have that approved ahead of time, so that wouldn't slow down their ability to invest.
It's true, right, that sometimes the AML process can take some time, right?
Depending the complexity of the entity investing, yes.
Right. I think on direct you described a process of drilling down, right?
Yes.
So drilling down can be simple sometimes, right?
Can be very simple.
And sometimes can be very complicated, right?
Can be very complicated.
So what makes drilling down particularly complicated?
When an entity is owned by entities.
I'm sorry, could you explain what you mean by that?
When an entity is not owned by a person, it's owned by additional entities, separate entities. So you could have entity A that's owned by entity B, C, D. And you have to keep drilling into the different entities until you find an actual person to do AML on.
Got it. Because you need the specific person in order to run them through AML, right?
Correct. Anyone who owns more than 20% of an entity is considered a beneficial owner, and needs to have an AML check.
Mr. Kamraju said, could we go back to Government Exhibit HN37 for a second? All right. It's not in. Take it down for the jury. I'm sorry, I thought you put it in. Can I just show it to the witness, the court? And the parties? Ms. Schottenheimer, do you recognize this document?
1 second.
Oh, yeah, please. Take your time.
Yes. I'm familiar with this email.
Okay. So it's an email chain, right?
Yes.
And it starts with emails between you and Mr. J.E., right?
Yes.
And Mr. Bass is copied on those underlying emails, right?
Yes.
And the time period of these emails is around May 29th, 2020, right?
Yes, sir.
And it concerns a side letter that Mr. J.E. was seeking, correct?
Correct.
Mr. Kamraju said, okay. The defense would offer Government Exhibit HN 37.
Mr. Finkel said, objection. Hearsay.
The court said, step up please.
At sidebar.
The court said, so the first email from Mr. J to Ms. Schottenheimer concerns the terms they were negotiating, correct?
Mr. Kamraju said, yeah. My only purpose in introducing the email is to show that Mr. Bass asked Ms. Schottenheimer to call him about the side letter. I'm not introducing it for the truth of any of the underlying materials. Just to say that Mr. Bass asked Ms. Schottenheimer to call. Which is basically one of the exceptions that we had talked about yesterday, I believe, an instruction or a direction.
Mr. Finkel said, he's certainly free to ask the question, did Mr. Bass contact you via phone to discuss whatever? Or in response to an inquiry from Mr. J.E.? But defense can't put in documents for declarants for Mr. Bass and Ms. Schottenheimer and Mr. J.E. We object on that basis. It's not being offered every time there's a hearsay objection, I understand. Obviously. As Mr. Ferguson mentioned yesterday, the devil is in the details on all these things. There's an explanation that it's for the state of mind or to show, in fact, that all these things. We disagree with that in this particular case. I don't object to the question. Did you speak with Mr. Bass on the phone in response to an inquiry from Mr. J.E.? That's fine. But the document is hearsay, and the government objects.
Mr. Kamraju said, on what basis is the document hearsay?
Mr. Finkel said, it's a third-party declarant who's not testifying. And it's also a statement by a co-conspirator, which they can't offer under the rules. That's the basis.
The court said, so you have William J. to Ms. Schottenheimer, then Ms. Schottenheimer to Kyle Bass. Certainly she can authenticate her email.
Mr. Kamraju said, and I'm only intending to ask her about the top email. And I think they've already introduced emails about this very topic between Ms. Schottenheimer and Mr. J.E. So we're not.
The court said, you're not seeking to introduce the first email from Mr. J.E.?
Mr. Kamraju said, I think you need that just to explain what the phone call was about. You know, I mean. I can certainly confuse the witness, offer an active version of it. And just have her not know what the substance of the phone call is. But we're not offering it for the terms that are being negotiated. I'm going to ask her that question. But all I'm really asking for is that setting up that Mr. Bass asked Ms. Schottenheimer to call him about the subject of the terms that Mr. J.E. wanted to negotiate. That's not offered for the truth, Your Honor. And until the government can articulate an actual basis, hearsay basis for it, there's no hearsay objection.
Mr. Finkel said, so there is a hearsay objection.
The court said, wait a minute. I thought it went from J.E. to Schottenheimer, Schottenheimer to Bass.
Mr. Kamraju said, so it goes J.E. to Schottenheimer, then Schottenheimer forwards the email to Bass and says J.E. wants this. And Kyle Bass responds, call me. So I'm not introducing it for the truth of what J.E. wants. I'll ask her that question, right? All I'm introducing it for is the idea that Kyle Bass says to her, she goes to Kyle Bass and says, you know. This is what he wants. And Kyle Bass says, call me and I'll explain it, which is a non-hearsay use.
Mr. Finkel said, Your Honor, if I may, what they want this in for clearly is for what J is saying. Because otherwise the question would be very appropriately put, Did you speak with Mr. Bass about what Jay wanted? That's if I can please finish.
Mr. Kamraju said, I haven't said anything.
Mr. Finkel said, that's an appropriate question. They are trying to introduce a document to get into the record Jay's statements, which the defense can't do. That is hearsay. I understand they have a view that it's not being offered for the truth. But merely saying so does not make it so. The government believes it's an authentic document. There's no dispute of authenticity. I'm not disputing authenticity. I'm disputing hearsay. On that basis, the objection, respectfully, should be sustained and we should move on and pose the question.
The court said, you're saying that it comes in as a command from Mr. Bass?
Mr. Kamraju said, I'm saying it comes in as a request from Mr. Bass to call me. It's just that simple. If Your Honor wants to put a limiting instruction with it to say they can't consider the underlying things. Whatever motivation Mr. Finkel is ascribing to, I am telling you that my only purpose. My only set of questions is to say, Mr. Bass asked you to call him when you contacted him about this, right?
Mr. Finkel said, so why not just ask that question?
Mr. Kamraju said, because I'm allowed to set it up, Ryan. I'm not limited to asking questions.
The court said, so the elimination of the J.E. to Schottenheimer email is acceptable to you?
Mr. Kamraju said, if you want. I think she needs the subject line because otherwise she's not going to know what the email is about. She's not going to know what the subject is. But if you want to redact, first of all, this is a government exhibit that was produced to us in this way. So this is not a defense exhibit. But second, if that is the concern, I just want to make sure that it is recognizable for the witness so that she understands what it is. But the fact that the government is unable to articulate a reason why our hearsay argument isn't valid other than saying that's not really what they want to do. Your Honor, it's not enough that you should reject the objection.
The court said, I think we established yesterday that commands don't constitute hearsay.
Ms. Strofa said, exactly.
The court said, but the G portion of it is hearsay.
Mr. Kamraju said, sure. Which Your Honor can easily solve by just saying don't consider the bottom part of the email for the truth.
Mr. Finkel said, I think it should be redacted. They can zoom in on the portion of the email that Your Honor is going to admit. They can prepare a redacted version of the document.
Mr. Kamraju said, but why do we need to redact it?
Mr. Finkel said, because it's hearsay.
The court said, what does the subject matter say?
Mr. Kamraju said, it says side letter is the subject line. And then he's talking about the terms of the side letter.
The court said, okay, so if she can testify that Mr. Bass wanted her to call, I have no problem with admitting that portion of the email without the William J.E. portion.
Mr. Kamraju said, okay. So how would Your Honor like me to handle it right now? Should I just focus on the top portion?
Mr. Finkel said, if I may.
The court said yes.
Mr. Finkel said, part of the reason the defense has said that they need the letter is because she doesn't know the subject matter, and she doesn't know this. Let's see what she knows. Maybe she remembers. That's number one. So if there's a failure of recollection, this can be used to refresh. That's number two. The third is based on Your Honor's ruling. They should just blow up. They certainly have the technology. If not, we can do it, the top portion of the email, and introduce that piece of the exhibit, and then they'll redact the rest.
Mr. Kamraju said, I should get both pieces. I should get Ms. Schottenheimer's email to Mr. Bass.
The court said, yes, I agree.
Mr. Kamraju said, and I should get Mr. Bass's response.
The court said, that's fine. Okay, that's how we'll go forward.
Mr. Kamraju said, thank you, Your Honor.
In open court, Government's Exhibit HN37 received in evidence.
Mr. Kamraju said, Your Honor, may I publish this portion that's on the screen?
The court said yes, you may.
Mr. Kamraju said, okay. Thank you. Could we publish it for the jury, please?
By Mr. Kamraju.
Okay. Ms. Schottenheimer, do you see your email to Mr. Bass there at the bottom?
Yes.
And do you see the subject is side letter, right?
Correct.
What is that a reference to?
That's in reference to the side letter that William J.E. had requested on behalf of the entities he was directing to invest in the Hong Kong fund.
And where you refer to terms with a minimum of a 1 million investment, what does that mean?
To my recollection, there was a version of the side letter that they were requesting the terms subject to $1 million minimum investment.
So they were asking for favorable terms on the $1 million portion of the investment?
It's hard for me to perfectly recall without the draft of the side letter. But it was my understanding that they were asking for these terms in connection with $1 million investment.
Okay. And it would be unusual normally for $1 million investment to be able to get any kind of side letter, right?
Correct.
Why did you reach out to Mr. Bass about this?
He was negotiating the side letter directly with William.
And was it your view that it was pretty aggressive to ask for a side letter in connection with $1 million investment?
I think I understood that there was some sort of miscommunication. At this point, I don't know, May 29th, if it had been represented to me that there was also a $50 million investment in the mix as well. And that the wording, I think, was just improperly outlined on the initial draft of the side letter.
Okay. And then how does Mr. Bass respond?
Call me on this. I will explain.
Did you speak with Mr. Bass about it?
Yes.
And what was the outcome of that conversation?
He explained that William J. wanted to invest $1 million personally in addition to the capital that was coming from Miles Kwok's family office. But it would be a separate entity.
And so?
The resolution.
Yeah, sorry. I didn't mean to interrupt.
The resolution was because they were affiliated entities. Our external counsel was comfortable drafting the side letter with a $51 million minimum. And I think, to the best of my recollection, that is what went into the final version of the side letter.
Was it 51 million or was it a 101 million that went into the side letter?
At one point I thought it was $51 million, at some point it went from 50 million from Soraka to 100. But I believe in the final side letter I thought it was 51.
Okay. Now, when we looked at the text message you mentioned starting, sorry. You mentioned starting anti-money laundering checks with Mr. J.E., right?
Yes.
Okay. And you testified on direct about what anti-money laundering checks are. They are part of the KYC process, right?
Yes.
And KYC stands for Know Your Customer, right?
Yes.
And you testified on direct that the SEC requires you to do those kinds of checks, right?
Yes, it's all yes.
And there are other government agencies that also have checks that are part of the KYC process, right?
It's broadly, I think. Financial institutions have to engage in KYC with any of their customers.
And they have to check the entities against various U.S. government lists, for example, right?
Yes. I'm really only familiar with our process.
Okay. Well, tell me your process.
We collect the required documentation outlined on the AML grid. We use SCI as our third-party administrator. And we have outsourced the AML function to our third-party administrator. They have a team that runs AML for our funds.
Got it. And are you aware what checks they run?
Generally, they check the names and details of all of the required persons to have AML. Beneficial owners, authorized signatories, and controlling persons against a world check database that checks against OFAC, and a number of other broadly kind of terrorist list or kind of persona non grata list. And they do this at the time of investment, and on a monthly basis. And they provide a report to us saying that there's no hit. We've never had a hit. So no hits on a monthly basis for each of our funds.
And, sorry, you mentioned OFAC. What is that?
I don't know the acronym.
That's okay. Just generally.
It's a list of terrorists. Not just terrorists, but people that you cannot do business with.
And so that's, checking against the OFAC list is one of the parts of the AML, right?
That is outsourced, yes, yeah.
Thank you. Now, you testified on direct about something you called an AML grid, right?
Yes.
And part of the AML grid is a list of questions for the investor to answer, right?
It depends on a lot of the AML, is baked into the questionnaire within the subdoc. The AML grid shows a list of the documents that you need to provide and the information that you need to provide on the ultimate beneficial owner. Controlling persons, and I think that's it.
Mr. Kamraju said, just 1 second. Now. You testified on direct that there was a time when Mr. J.E. told you that money would need to come from a different entity. Right?
Yes.
And that was, from your perspective, that might have been an AML problem, right?
It was.
And Mr. J.E. ultimately resolved that problem, right?
The money came in from an account from Saraka.
Right. And so that fixed the AML concern that you had, right?
Yes.
And, sorry, I forgot to ask the question before, but just going back to the side letter quickly. It's not unusual for larger investors to get side letters, right?
Not unusual.
And the terms of those side letters and what, withdrawn. What Hayman is willing to agree to in a side letter is based in part on the economics of the investment, right?
I don't understand the question. Can you please repeat it?
Sure. If an investor is asking for particular terms, right?
Millimeter Herm.
One of the factors that would go into Hayman's decision as to whether to accept those terms is the size of the investment. Right?
Yes.
Now, in the subscription packet, right, one of the questions is source of wealth, right?
Yes.
Now, the subscription packet did not always have a source of wealth question in it, right?
That's correct.
That was added over the last few years, right?
Few years from 2020, yes.
I'm sorry, you said yes.
Yes.
Okay. And you testified that at first, the Saraka form was missing the source of wealth information. Right?
Yes.
That's also not unusual, right?
It is typical for there to be corrections in a subdoc. For that question to be skipped. It's been skipped before, but I don't think it's a regular occurrence.
Right. You had other investors who have failed to fill that in, right?
Yes.
And you've had investors who were confused about what that question was seeking, right?
Mr. Finkel said, objection. Calls for speculation.
The court said, sustained.
Well, you personally have dealt with investors who have been confused about that, right?
Mr. Finkel said, same objection.
The court said, sustained. Can't speak to what other people are thinking.
You personally have had other investors express confusion to you about that question.
Mr. Finkel said, same objection.
The court said, sustained.
Mr. Kamraju said, okay. Can we go to Government Exhibit HN 51?
Counsel conferred.
Do you recognize this?
Yes.
Okay. The defense offers Government Exhibit HN 51.
Mr. Finkel said, no objection.
The court said, it is admitted.
Government's Exhibit HN 51 received in evidence.
Mr. Kamraju said, can we publish that, please? All right. So this is you see where it says, briefly identify subscribers, right?
Yes.
Okay. So this is the specific source of wealth question for the Soraka subscription package, correct?
Yes.
And what's listed there is selling shares of subsidiary, right?
Yes.
Now, nothing in that description raised a red flag for you, right?
Correct. It looks like a liquidation event to me.
And you didn't ask for any additional information about it at the time, right?
Nor did SCI.
Well, that was going to be my next question. You passed it along to SCI for them to review it, right?
I did.
They didn't come back with any follow-up questions about it, right?
Correct.
And they are the AML experts, right?
We rely on their expertise.
That's what you pay them for, right?
Correct.
Mr. Kamraju said, "Now, can we pull up Government Exhibit HN57, please? And we can publish this to jury." All right. Now, this is an email from Mr. JE to you, right?
At the top.
Yeah, at the top.
Yes.
Okay. And it's CCNG Mr. Base, right?
Yes.
And there are a number of attachments to it, right?
Yes.
And these are documents that you required or Hayman required for the Soraka investment to go through. Right?
Yes.
Mr. Kamraju said, "So can we go to page 7? Maybe let's go to the page before that." Thank you. So you testified on direct about this, right?
Yes.
And you see the primary contact there?
Yes.
What's the email address listed for the primary contact?
AIAudio@gtv.org.
Now, while this subscription agreement documentation was being collected, Kyle Bass was discussing being a director of GTV, correct?
Mr. Finkel said, objection.
The court said, sustained.
Were you aware that during this period when the subscription documentation was being collected, Kyle Bass was having discussions about being a director at GTV?
No.
GTV is a subsidiary of Soraka, right?
I don't know.
Mr. Kamraju said, "Pull that down for a second. And can we go to page 39? Do you see an email address listed there, right?
Yes.
Same email address, right?
Yes.
Mr. Kamraju said, "May I just have one moment, Your Honor?"
Counsel conferred.
Did you ever become aware that Mr. Bass was trying to become a GTV director?
Mr. Finkel said, objection. Asked and answered.
The court said, sustained.
Mr. Kamraju said, "Could we pull up Government Exhibit HN 168? 168, not in. Okay. Can we go to the attachment, please? Now, you remember you testified about this on direct, right?
Yes.
Okay. And there's a list of questions that you testified to, right, in this letter?
The bullets, yes.
Now, Hayman never asked any of these questions prior to accepting the Soraka investment, correct?
Correct.
This only was prompted by the SEC's inquiry, right?
Yes.
And Hayman at the time relied on the SEC's approval to do business, right?
In what context?
Well, you testified that they are a registered investment advisor, right?
Hayman at the time was a registered investment advisor with the SEC. So they are our governing body.
Right. So they could, I don't know if it's the right term, but they could deregister you, right?
Yes, potentially. I'm not really clear on that, but yeah.
But you didn't think there was anything wrong with Soraka's original response, correct?
Mr. Finkel said, objection to the form. Vague.
The court said, overruled.
Can you please repeat the question?
Sure. Mr. Kamraju said, "Can we read it back, please?"
Record read.
Soraka's response in the subscription document regarding the source of wealth was sufficient for the AML requirement to subscribe to the Hayman Hong Kong Opportunities Fund.
Okay. And you testified on direct that you had discussions with Mr. Bass about the SEC's inquiry, right?
Yes.
Do you recall Mr. Bass ever criticizing the SEC's inquiry?
I can't recall any comments at this time.
Was he happy about the SEC's inquiry?
Mr. Finkel said, objection. Asked and answered.
The court said, you may answer.
He was not happy.
He was upset about it, right?
About the inquiry.
Yeah.
I think he was upset about being lied to by where the funds were coming from.
Sure. And he wouldn't be happy about the SEC investigating either, right?
Correct.
And did you hear him express his unhappiness about it?
I just can't recall a specific conversation about it.
Now, on direct, Mr. Finkel asked you whether HHKOF involved. His phrase was a bet against the Hong Kong dollar, right?
Yes.
Hayman isn't a casino, right?
No.
Not a sports book, right?
Correct.
Hayman doesn't make bets, it makes investments, right?
Correct.
And he asked you about Mr. Kwok making an investment in Hayman, right?
Yes.
He asked you about Mr. Kwok sending $100 million to Hayman, right?
I can't recall if it was Mr. Kwok specifically or Mr. Kwok's family office but yes. Generally, Mr. Kwok.
Okay. And today he asked you questions about the Soraka/Kwok investment, right?
I believe so.
Okay. Mr. Kwok never made an investment in Hayman, right?
Personally, no.
His name doesn't show up in a single investment at Hayman, right?
Correct.
Not as Ho Wan Kwok, right?
What are you asking? I apologize.
I'm saying there's no Hayman investment in the name of Ho Wan Kwok, right?
Sorry. Can you spell it?
Sure. H-O, space, W-A-N, space K-W-O-K.
Correct.
There's no investment in the names of Miles Kwok, right?
Correct.
There's no investment in the name of Miles Guo, right?
Yes.
And you know that because if there was an investment in Mr. Guo's name, you'd have done an AML on him. Right?
Yes.
And that's true if the investment was in his own name, right?
Yes.
And that's true if he even owned just 20% of the company that made the investment, right?
Yes.
But based on the documentation, you did not think it was necessary to do any AML on Mr. Guo, right?
Correct.
And in either circumstance, you would have to do the drill-down process that you were talking about. Right?
If he'd invested in an entity that he owned or invested in his name.
Yes.
Would there have been AML checks either way?
Now, the investment was in the name of a company owned by Mr. Guo's son, right?
Yes.
And you did I think you testified on direct you did a thorough review of that file, right?
Of the subscription agreement.
Yeah.
Yes.
And you thought that this investment was coming in through Mr. Kwok's family office, right?
Yes.
It's not unusual for a family office to involve multiple members of the family, right?
Not unusual.
Right? The investments can be on behalf of different family members, right?
Yes.
Doesn't always have to be the father, right?
Correct.
And it's not unusual for people to involve their children in their family office, right?
Very common.
But the fact that an investment is made by one of Mr. Guo's relatives does not make it Mr. Guo's investment. Right?
It was my understanding that the wealth amassed was, in fact, Mr. Miles Kwok's.
Continued on next page. By Mr. Kumraju.
But you didn't do any AML check on him, right?
We weren't required to.
You didn't do any due diligence on him, right?
Meaning?
Well, you testified on direct about the phrase, due diligence, so whatever meaning you gave it. Same one.
There was no formal AML done on Mr. Kwok, Mr. Miles Kwok.
Which you would have had to do if you thought that this investment was his, right?
If he was listed as a beneficial owner, an authorized signatory, or controlling persons. But given the representatives provided by Soraka Media, that was not the case.
I'm sorry. Your testimony is that you thought that the money was his but you didn't need to figure out whether the entities were. Is that right?
Mr. Finkel said, asked and answered.
The court said, sustained.
Now Soraka came through the onshore fund, right?
Yes.
Which means that they would get a K1, right?
They had a tax ID with the United States, and they would get a K1.
Now you testified that you only met Mr. Gov't once, right?
Correct.
And in this courtroom is the first time you've seen him since 2018, right?
Yes.
But you met with the prosecutors several times, right?
Yes.
More than 5 times.
Yes.
In fact, you met with them just a couple hours before your testimony started yesterday, right?
Briefly.
Over the lunch break?
Yes.
Just downstairs in this building, right?
Yes.
And at all of those meetings, you discussed your testimony with them, right?
In meetings, I answered questions truthfully.
Right. They asked you questions, you gave them answers, right?
Yes.
And in anticipation of your testimony, they told you what questions they anticipated asking you here today, right?
Not necessarily.
They showed you the documents that they were going to show you, right?
They showed me documents, yes.
They asked you questions about those documents, right?
They asked questions.
They showed you those emails that we looked at, right?
Yes.
Now in none of those emails do you refer to it as the Gov't investment, right?
I don't believe so.
Right. That was Mr. Finkel's choice of words, right?
Yes.
That's his description, not yours, right?
I've described the investment and spoke to the investment, however, whatever word choice I've used. Miles' family office primarily called it Soraka, by the actual name of the entity that invested.
So you don't recall him asking you questions about the Gov't investment and you describing it that way?
Mr. Finkel said, asked and answered.
The court said, sustained.
Ms. Schottenheimer, you would agree with me, right? It's not accurate to call it the Gov't investment. Right?
At the time of May of 2020 and June of 2020. I thought of it as Miles Kwok's investment from his family office.
So you just didn't follow the procedures that you would need to if you did that, right?
Not correct.
Mr. Kumraju said, no further questions, Your Honor.
The court said, redirect?
Redirect examination. By Mr. Finkel.
Ms. Schottenheimer. Did you follow the procedures that you're required to follow when conducting the facilitation of the Soraka $100 million investment?
Yes.
Ms. Schottenheimer, during the meetings you had with the government, what did the government tell you to do when you testified?
Tell the truth.
Is the prodigious series offered to the general public?
No.
Is it offered to qualified purchasers?
Select qualified purchasers.
And why is the prodigious series only offered to qualified purchasers? Select qualified purchasers.
Because we rely on a 3(c)(7) exemption, and in order to maintain that exemption, we have to make sure that we are only marketing to sophisticated investors with a net worth of, or investable assets of $5 million or more.
And why is the prodigious series only marketed to sophisticated investors?
Because of how we have the fund structured, it's a 3(c)(7) fund.
You mentioned something on cross-examination about multiple closing dates. Can you explain to the jury what that means?
So for the share Class B or prodigious series, that the Hayman Hong Kong Opportunities Fund. Because it is 100% options-based and a capital exhaustion strategy, there's no money in or no money out. Once we have a closing, We have to have a series of closings in order to take in new capital. So to date we've closed B1 through B12.
So the Soraka investment, the $100 million investment, what was the closing date of that?
June 8th.
And was there a June 1st closing?
There was.
And so why was there a second closing on June 8th?
It's my understanding that that timing was too tight for them.
Too tight for whom?
Too tight for Soraka to participate.
Mr. Finkel said, would you bring up what's in evidence as HN57 at page 7, I believe. Ms. Schottenheimer, do you recall this document?
Yes.
It says, total number of equity/capital/or beneficial owners of the investor.
Yes.
Why does Hayman request that information?
So we can understand how many beneficial owners are and who we need to collect AML on.
And so if this number was 2, how would that impact, if at all, the way you perform diligence on this particular investment?
Well, it would be dependent on what was provided to us. If each beneficial owner owned 50%, then we would do AML checks on both. But if one owned 90% and the other owned 10%, we'd only be required to do AML checks on the individual that owned the 90%, or more than 20%.
But this question isn't a question about who owns 20% or more. Or is it a question about total number of beneficial owners?
This is about total number.
Mr. Kamraju said, I object to the form.
The court said, overruled.
So this representation is that there's just one investor for the Soraka investment, correct?
Who owns 100% of Soraka, correct.
And that's who, based on the documents?
Miles Kwok's son.
Mr. Finkel said, if we can bring up, please, HN51. And if we can zoom in at the top. You were asked some questions about this document on cross. Is that correct?
Yes.
And so it says on there, briefly identify the subscriber's primary source of wealth. It says, selling shares of subsidiary, correct?
Yes.
If Hayman had known that Soraka's source of wealth were GTV investors, who were not told that they were investing in the HHKOF, would you have accepted Soraka's investment?
Mr. Kamraju said, objection to form, Your Honor.
The court said, sustained.
Ms. Schottenheimer, if you had known in early June of 2020 that this statement, selling shares of subsidiary, was a lie, would you have accepted Soraka's investment?
Mr. Kamraju said, same objection.
The court said, sustained.
If you had known that this statement, selling shares of subsidiary, was untrue, would you have accepted Soraka's investment?
Mr. Kamraju said, same objection.
The court said, sustained.
Mr. Finkel said, Your Honor, I thought this was consistent with, could we approach?
The court said yes.
At the sidebar.
The court said, so my recollection is that I permitted hypotheticals to the victim, not to a company like this.
Mr. Kamraju said, that's right, Your Honor, because it goes to materiality.
Mr. Finkel said, so, Your Honor. The Second Circuit has now adopted what I think is commonly referred to as the conversions theory. What that means is that, in a wire fraud context, the crime can be completed based on any action in furtherance of the scheme that is a misrepresentation. Therefore, the government would argue, in part, that part of the scheme was maintained by this lie. In addition, Your Honor, government also charged the last count of the indictment, which statute is escaping me right now, the 1957 charge, which is the illegal use of funds, which is use of funds derived from a crime. The fact that they're lying to Hayman about where the funds came from is evidence of relevance to that particular charge in and of itself. So my understanding, Your Honor, forgive me if I misinterpreted the court's prior ruling. That's why I asked the question, because I thought it was consistent, I think it is relevant because it shows that had they told the truth, the entire way the scheme would have unfolded differently. It would have failed.
The court said, "So my recollection is that you were speaking about the individual victim investors in your motion. That's my recollection. Am I wrong about that?"
Mr. Finkel said, "I think you're right. But separate and apart from that, I still think this is a permissible hypothetical question for the reasons I just identified."
Mr. Kamraju said, "There is no authority to asking a hypothetical question to a non-victim."
The court said, "I'm sustaining the objection."
Mr. Ferguson said, "Just a final point on the conversion theory point, Your Honor. Materiality is an element if that material misrep was made to a victim or to someone else. And that's Second Circuit law. You don't have to make the material misrep to a victim."
The court said, "Why didn't you bring it up in your papers then?"
Ms. Strofa said, "Exactly."
Mr. Ferguson said, "We thought."
Mr. Kamraju said, "Seems like that's the answer to me."
Ms. Strofa said, "That answers the question right there."
The court said, "I'm going to sustain the objection."
Mr. Kamraju said, "Thank you, Your Honor."
Continued on next page. In open court.
The court said, "Sustained."
By Mr. Finkel.
Ms. Schottenheimer, you were asked some questions on cross-examination.
Ms. Strofa said, "Your Honor, I'm sorry."
Mr. Kamraju said, "My apologies, Your Honor."
The court said, "Go ahead."
Mr. Finkel said, "Thank you, Your Honor." Ms. Schottenheimer, you were asked some questions on cross-examination about at the time that Hayman received this representation. Whether you asked any additional questions about selling shares of subsidiaries. Is that correct?
No further questions were asked at the time of processing the subdoc.
But after the subdoc was processed, did Hayman and its lawyers ask questions about the source of wealth?
About the source of wealth and the source of funds.
Mr. Finkel said, "If we can please pull up what's in evidence as H in 168, and go to the second page. And this document, these were some of the questions that were asked to Soraka about the source of wealth. Correct?
Source of wealth and source of funds.
What's the difference between the two?
Source of wealth is how you created your money to be a qualified purchaser. The source of funds is what funded your investment into the vehicle."
And the third bullet, it says, if the proceeds were derived from a securities offering. Did the offering documents disclose the use of funds to include an investment in the fund, meaning Hayman, or in any similar private fund vehicle? If yes, please provide a copy of the disclosure statement. Did I read that right?
Yes.
Did Soraka ever provide offering documents in response to this question?
No, they did not.
Did Soraka provide any additional information to suggest that they disclosed that the use of proceeds from a securities offering would be used in Hayman?
No, they did not.
Mr. Finkel said, "If we can pull up HN 208. This exhibit is another example of Hayman seeking additional information about the investment?"
Yes.
And did Soraka ever respond to this?
They did not.
And so in the second paragraph, the underlying text says, in order to allow Soraka to remain invested in the fund, Hayman needs to receive a representation from you and Soraka's lawyers regarding the specific source of this money, beyond what was initially provided stated in the subscription documents, and that this money is not tainted in any way, including that it does not represent assets from the GTD offering, but that it is a bona fide investment made by Soraka and Miles. Is that what it says?
Yes.
Did Hayman ever receive a response to this?
We did not.
Mr. Finkel said, "Nothing further."
The court said, "Recross?"
Mr. Kamraju said, "Just briefly, Your Honor." Mr. Kamraju said, "Could I have 168, please?" Recross examination.
By Mr. Kamraju.
So Ms. Schottenheimer, the date of this email is July 15, 2020, right?
Yes.
And the SEC had already contacted Hayman by this point, right?
The 13th of July.
Right. Right. And Mr. Finkel just asked you a number of questions about whether you ever received a response. Whether Hayman received a response, right?
A formal response.
Right. Now sitting here today, you don't know what Mr. J.E. and Soraka were doing during this period. Right?
Correct.
You don't know if they were consulting with lawyers, right?
Mr. Finkel said, objection. The court ruled on that.
The court said, sustained.
Okay. You testified during direct that Soraka had lawyers, right?
Yes.
You don't know if they were discussing the matter with the SEC directly, right?
I would not have been privy to those conversations, so I don't know.
Right. But you testified on direct that at some point you wired the money back, right? Some portion of it?
We wired money to an escrow account.
Okay. An escrow account that was held by who?
It's my understanding they were Soraka's lawyers.
Okay. And you did that with the blessing of the SEC, right?
With no objections from the SEC or the DOJ.
Or Soraka, for that matter, right?
Correct.
And then you also testified that you liquidated the $30 million position at some point, right?
Yes.
And that was 15 months later, right?
Would have been maybe late September, early October of 2021, 15 months, yep.
And the SEC knew that that $30 million was there, right?
Mr. Finkel said, objection.
The court said, she cannot testify as to what the SEC knew.
The SEC had asked Hayman about that $30 million before, right?
I was not a part of any of the direct conversations with the SEC.
But on direct you testified that when that $30 million was ultimately liquidated, it was done with the consent of the SEC, right?
It was my understanding at the time that there was no objection from any of the parties. From the SEC.
Okay. And on direct you said, I don't remember the exact term, but any of the interested parties, right?
Regarding the 70 million, or the 30 million.
30 million.
I don't recall saying that about the 30 million.
Okay. Anyone object to you liquidating the $30 million position?
Not to my knowledge.
You never heard Soraka object to it?
At the time.
At the time it was liquidated.
I don't know.
Mr. Kumraju said, no further questions, Your Honor.
Mr. Finkel said, one question, Your Honor.
The court said, all right. Redirect examination.
Redirect examination. By Mr. Finkel.
Months later, when the SEC became involved, as you were just asked about, at that time did anyone from Soraka respond to the questions that Kit Adelman had asked and provide documentation about the source of funds and source of wealth?
Mr. Kumraju said, objection to form.
The court said, overruled. You may answer.
There were no responses that I'm aware of.
Mr. Finkel said, nothing further. Thank you.
The court said, any reary cross?
Mr. Kumraju said, no, Your Honor.
The court said you may step out.
Witness excused.